For this section, we're going to talk about an exciting topic. We're going to talk about intellectual property, which might be or probably is a core aspect of your business. And we're going to first kind of talk about a story to set the stage of what we're looking at and some of the issues that can come up with intellectual property in a technology business or any business organization, really. So the main question we're going to be thinking about is who owns your IP? Who owns your intellectual property? We're going to think about this in the context of some other questions. Who created it? When was it created? Where and why was it created? And how was it created? What type of intellectual property it is? And then lastly, we're going to talk about, the practices in place that you need to have to properly transfer your intellectual property rights to the business. So first, let's start with the story. A few years back, I was working on a sale of a startup company, and we had gotten very, very close to the end of the transaction. But we had two hurdles that had occurred along the way, and all of them were tied to intellectual property. So some of the early parts of that business were developed with overseas developers. Okay, so this is pretty common, especially in the beginning part of a business where it is a little bit cheaper and more efficient to have some core aspects of the technology developed overseas. And so although we had an agreement in place, the client had an agreement in place with the individual contractors that had a development shop overseas. One of the things that needed to be clarified was whether or not that contractor overseas had agreements in place with its individual employees or contractors who had developed the physical who had developed the actual code for the product. And so the potential buyer wanted to make sure that that title was very clear when who exactly developed that intellectual property. It was made sure it was clear that the individual contractors or individual employees of that foreign contractor had assigned their rights over. Long story short, there were a few that were missing that they had not, on their side of things, gotten agreements signed over for. And as you can guess, some of those individuals were no longer with the company. So they had to employ counsel to go ahead and track down these Ukrainian developers and get them to sign agreements transferring their intellectual property rights right before the scheduled time of closing, which held things up quite a bit. Similarly, on other transactions, we've had situations in which, the founding team had left. Right. So some of the founders had left, at a relatively early stage. And so when we got to the time for exit, for sale of the company, there was some questions as to their ownership and whether or not those individuals transferred the intellectual property rights that they created at the time they were actually working with the company. When that isn't the case, it's difficult to get signatures at that point in time, as those former founders might have left on bad terms, or those individual employees might not have left on great terms. And they also think that there's a chance to, cause a little bit of issues and maybe have some leverage and get a bit of a payout. So you want to make sure you're handling all these things in the front end. And one of the first questions that you're going to ask when you're talking about who owns the intellectual property is who created it. Often ownership of intellectual property is determined by who created the IP. Was it a founder, employee, or third-party contractor? If it's a third-party contractor, is that third party an organization? That does not necessarily mean that organization owns the IP, as we heard in our story, right? That individual contractor that the client had a contract with still had to make sure it had its own intellectual property rights from its individual employees so that that chain of title was clear. Unless an individual employees assign their rights to the contractor, that contractor might not even own the IP rights. And obviously, this can cause difficulty in obtaining those rights from the contractor because the contractor doesn't have the full rights to give you. So there's a chain of title issue. So it's always important to know when it was created. And also, when and how was the IP created? Was the IP created before or after the company was formed? If it was created before the company was formed, then you know it's not owned by the company, right? Because the company wasn't even formed yet. So you're going to need to have some type of affirmative assignment, some type of affirmative transfer from the individual that created it to the company itself. Also, was the IP created as part of somebody's employment? Okay, if it was created by an employee as part of their job, or was it created while they're an employee of another job? Under under what situations was it created? Was it created a part of university research? Was it created by a contractor through some third-party website? What does that third-party website own? What does that individual third party own? Was the IP created pursuant to some written agreement? This is obviously one of the most important aspects of it, right? You need to have a written agreement in place in a lot of situations to make sure that the IP is properly assigned. And so even when you have a written agreement in place, it needs to have the right language in it. Assignment of intellectual property requires very particular language. So what exactly does the document say? Does it say that the individual agrees to assign their intellectual property rights? Well, an agreement to assign their intellectual property rights is just the promise to do something in the future. It's not actually assigning anything at this time. So that agreement needs to say that the contractor hereby or the individual hereby assigns their intellectual property rights. That is a present assignment of intellectual property rights. So as far as best practices, what's the best way to handle all these things? Initially, a core document that should be included in any technology company is a confidential information and invention assignment agreement as a part of the onboarding process. We've discussed this agreement a little bit in the context of hiring. We're talking about it again now. This agreement's going to cover the type of access and the ability and the requirement that employees, service providers, or anybody who's actually touching the intellectual property of the company maintains confidentiality, confidential information and other proprietary information, that they're going to sign their inventions or their creations done within the context of their employment, such as the invention specifications in other forms of creation. It's also going to include restrictive covenants such as non-disparagement, non-competes, and non-solicitation of employees. And so this is a very important aspect of any onboarding process when it comes to IP. And so you're going to need to make this a standard document included in that onboarding process. Even when an individual or a contractor is not an employee, there needs to be some variation of a CIAA or a confidential information and invention assignment agreement. Often this is included as either an exhibit or the language is included within the body of an independent contractor agreement, which also includes very defined deliverables. You want to be able to point to what you paid that contractor to do and have it included very specifically so that you know what intellectual property rights that you actually own in that deliverable. So that's a run through of the intellectual property rights and making sure that intellectual property rights are properly assigned and owned by the company. And so I hope that you found this helpful. Until next time, venture awaits.